This is Officer CJ, and you're listening to the Crenshaw Criminal Justice Learning Tools podcast. Today, we're going to go back in time to take a glimpse at a brief history of juvenile justice in America. We're going to pull back the curtain on how we, as a society, have dealt with kids who break the law. So let's start at the very beginning, back in what is called the Puritan period, roughly the late 1500s through the early 1700s, where colonial America didn't really have a separate system for kids. The law was the law. If a child committed a crime, they were often treated just like an adult. They could be put in the same jails, face the same judges, receive the same harsh punishment. Then came the 19th century, the 1800s. Cities were growing, and so were problems like poverty, vagrancy, and crime. People started to see that throwing children into adult prisons was a terrible idea. This led to the refuge period, where houses of refuge and reform schools were created for juveniles. These early reformatories, the first one being opened in New York City, were designed to provide a more structured and disciplined environment than adult prisons, aiming to educate and rehabilitate poor, neglected, and delinquent children to prevent them from becoming criminals. But the reality during this period in history was often grim. Military-style discipline, long hours of labor, and very harsh living conditions. As we moved into the late 1800s, a powerful new idea started to gain ground. This was the concept of parens patriae. Parens patriae is a Latin term that means parent of the country. The idea is that the state has a right and a responsibility to step in and act as a guardian for those who can't care for themselves. This wasn't just about punishment anymore. It was about protection. Progressives were social reformers who believed society could be improved through government action and scientific knowledge. They argued that a child's environment, such as living in poverty, coming from a broken home, a lack of education, was a major cause of delinquency. Punishment alone wouldn't fix these problems. You had to address the root causes and rehabilitate the child. Parens patriae gave reformers the legal muscle to do it. All of this came to a head in 1899 in Chicago, Illinois, where social reformers, lawyers, and activists successfully established the very first juvenile court in the United States. It was a revolutionary concept at the time. The goal was to figure out what was in the best interest of the child. Proceedings were informal, records were kept private, and the judge acted more like a concerned parent. The focus was on diagnosis and treatment, not on crime and punishment. The idea soon spread across the country. By 1925, almost every state had a juvenile court. These courts had broad power, handling criminal acts and status offenses like skipping school and running away. It was hopeful, but it also had problems because having such broad power without sufficient checks could harm children. Next, the due process revolution would reshape the system again. For the first half of the 20th century, the juvenile court operated with the best intentions, but kids' legal rights were often ignored because hearings were informal. Children didn't have the right to an attorney, to confront accusers, or to remain silent. In the 1960s, the Supreme Court looked closely at this, culminating in re Gault in 1967. The court ruled kids had the right to notice of charges, the right to an attorney, to confront witnesses, and protection against self-incrimination. Following the court, Congress acted. In 1974, they passed the Juvenile Justice and Delinquency Prevention Act. The law gave federal funds to states, but with strings attached. Deinstitutionalize status offenders and create sight and sound separation. The JJDPA pushed for community-based alternatives, keeping kids out of secure detention whenever possible, while its sight and sound rule prevented juveniles in detention or confinement from having physical contact with, seeing, or hearing incarcerated adults, thereby shielding them from abuse and exploitation. The act reshaped the system, moving it toward rehabilitation and protecting kids' rights. Just as the system was moving in this direction, the tide turned again in the 1980s and 90s, when sensationalized media accounts and academic predictions created the idea of the super predator, a criminological term for a remorseless, violent juvenile offender. Legislators began pushing what is known as get tough measures, making it easier to transfer juveniles to adult courts and calling for mandatory minimums. Kids ended up in adult prisons with long sentences and felony records. It took decades and a lot of science to begin to undo this damage. Today, juvenile justice reforms emphasize evidence-based practices such as functional family therapy, restorative justice programs, cognitive behavioral therapy, trauma-informed care, and substance counseling. Looking back from the Puritan period to today, we see the evolution of punishment, protection, control, and rehabilitation of juveniles, and that work continues. Well, that does it for us today. If you enjoyed the podcast, please like and subscribe for more great content from Crenshaw Criminal Justice Learning Tools. And if you're a teacher looking for awesome classroom lessons, resources, and activities, visit our website at ccjltresources.org. This is Officer CJ reminding you that education is empowerment. Thanks for tuning in.